went high level about that pool situation?
Yeah.
I would love to hear. My thing is practitioner.
Mm-hmm.
Practitioner, man. Forget theory and all that.
Yeah.
I'm like, you doing this stuff. So this
Yeah.
pool thing with this, let's just kind of, can you just give them a 20,000 foot view of what that looked like?
Yeah. So I've got in my office, I, s- I close a lot of houses around Lake Norman, and these are expensive houses. Not always, but expensive
Expensive means
houses.
what? 800, 1.5, 2.5?
1.5 plus up
Okay.
to people paying 3 million cash for houses. Like
What?
it's insane. So expensive houses have expensive pools, and they've got expensive pool repairs. So this buyer gets their inspection, and they see like, okay, the pool is it needs some stuff done, and the
Uh-huh.
seller's like, yeah, okay, I agree with you. What do you think needs done? Let's find a contractor to get it done. So they get
This
an
is all pre-closing.
Yeah,
Okay.
this is during due diligence period.
Gotcha.
They find a contractor and agree on the amount. Even they say, "Yep, this is a quote. We're going to pay. Seller is going to pay this amount," and the contractor couldn't get started before closing. So my preferred method is if you got repairs, get them done before. I just made a whole video on this like not even an hour ago. Get them done before closing and make sure you're doing your walkthrough to make sure that the repairs were actually done before closing if you've agreed to have them done. But this was not feasible for them. So the
Sometimes.
pool wasn't going to be repaired for another month or two. So we did something called an escrow agreement. Escrow means a lot of things in a lot of different states, but in this particular situation, it was escrowing some of the seller's sale proceeds to be used to pay for the pool repairs.
So they held
Mind
it back.
you, yeah, held back the money, and that they've already agreed. They've already agreed to the amount. They've already agreed to who's going to be fixing it. So pool contractor comes out and says, "Okay, I need this much to get started." And the seller
After
says,
close, after
"Mhm,
closing.
So they
Okay.
sign their escrow agreement, and the pool contractor says, "I need this much to get started." And the parties say, or the seller says, "No, it's too high. It's too much. I'm not.
But
I'm
they
not
already
paying."
agreed to it.
Bingo. So in our state and in our escrow agreement, what it boils down to is if the seller is going to refuse to pay, then the buyer is going to have to take them to court. So the escrow holder at that point, becomes a neutral party. It doesn't matter who they represented in the transaction. They are Switzerland now. They got to get out of the middle of it. They got to pay the money to the clerk of court, and then
Oh, wow.
the clerk of court gets to decide.
Oh my
So
gosh.
I hear you say a lot in your videos, control everything. Once you've paid that money to the clerk of court, you have given up your control. So I 100% recommend parties work it out, figure it out. If you can't get the repairs done before closing, yeah, the escrow agreement is a handy tool, but um, you don't want to have to delegate your authority to someone that doesn't know the situation. The clerk of court is going to listen to the seller side and the buyer side, and they're going to decide, and whatever they decide is the answer. So, you might be, it's, you never know what to expect in
You
court,
don't know. But I'm just
ever.
trying to figure out what dollar amount. Are we talking 50,000, 40?
Yes, actually, that's right on the money. Yeah.
I don't know why people would want to escrow. I could see 5 grand and maybe even 10,
Mhm.
but I'm like, that is such a large amount of money.
Yeah,
Don't people?
it's these lake houses, man. There's it happens a lot with like piers in Lake Norman as well.
Gotcha.
So our lake is regulated by an energy company. It's a
Hmm.
man-made lake, so they decide who gets to have a dock or not.
Okay.
And if the dock's not properly permitted, that affects the value of the home significantly.
Mm.
And they'll say, okay, well, I understand that Duke Energy might be running behind on issuing your permit. We'll go ahead and close, but if the dock ends up not being permitted, I'm getting 80,000 or whatever it may be, depending on the value of the house.
I see. I
Or
see.
if you added something to it that's not allowed to be there, you're going to pay X amount for me to fix that, so we can get it in compliance. So that's a really common scenario, and
That's deep.
Eight
That's
out
deep.
of 10, 8 out of the last 10 escrow agreements we've seen come through our office, whether we have prepared them or been involved in them or not, have been a dispute.
Oh man,
Mhm.
that is so deep. Wow, I didn't even know that there were that much. I've always paid. I mean, I didn't even know you could even not pay. I mean, it's not
Yeah.
even, the money's, matter of
Yeah.
fact, you've already paid it, right? I mean, you've
Yeah.
already lost the money at that time.
Yeah. Well, and also you're a person that honors their agreements. So,
Ah,
you know,
that's sick, man.
yeah.
All right, let's do this. So, real quick before I haven't even done the introduction. What is the moral of that story? The moral of the story is what?
Well, to me, it is if you already agreed on paper to do the thing, because otherwise you're going to have to give up your authority to a court and it might not come out the way you wanted. Um,
On the
so,
seller side.
well, yeah, yeah. I mean, it can go buyer's way too. Sometimes the seller does the thing, but buyer said it wasn't good enough, so I'm not going to release your extra money back to you.
That's
I
that
mean,
mess.
we've identified the issues. The parties both said this is what matters to us, and this is how we decide when it's done. And then suddenly, that's no longer good enough when somebody gets the idea of, oh, I can get $200 back that I wasn't expecting.
That is that mess.
Yeah.
I got out of that. I'm like, look, I'm giving you money. I'm not doing any more repairs after closings. They don't like the color. They don't like the size. They don't like the design.
Mhm.
Oh God.
Yeah, the answer to that is don't do the escrow agreement. Figure it out another way. You can handle it other creative ways. You can do the seller paid closing costs. You can just pay the contractor and hey, contractor, get it done. You don't have to do the escrow agreement, but people tend to like that one at the lake for some reason.
Round up homies. Listen, man, y'all know Tiffany has to be real like political with these answers and kind of she can't really advise with legal stuff. But I want you not to be trying to pick the buyer's brains. How many repairs have I done for a buyer and it not be what they like? Oh my God. I got out of that business maybe 10 years ago. Don't do it. Don't do it, man.
Mhm.
All right. So, greetings, class. What's going down? It's Chris Haskins again today with we're with Tiffany Webber, and we are starting up. We are going to see if we can create some synergy to do a weekly broadcast for you for attorney time. We want to make sure that you are understanding all the strategies for pro real estate investors, and not only to help you make more money. We all want to make more money, but do the right thing, have integrity, be honest, and make sure you take care of your community. In my opinion, is really where you win. Tiffany Webber, how you doing?
I am great. How are you? I
Man,
know you got a
everything's good.
storm.
Yeah, I think it's passing, so I think we're good now.
Nice.
So, for the few people that may not know who you are, real quick, give us just a brief history on your
Yeah.
background, Tiffany. And how did we get here?
I am a North Carolina real estate attorney in Mooresville, and my law firm's name is Thomas and Webber. That makes it sound like I have a partner. I did have a partner. He passed away last year. So I'm the
Darn.
principal attorney. I do have some other attorneys that work for me. So we got multiple attorneys in the office, but we keep the Thomas because we want to honor him. But we got the real estate firm. I do almost exclusively real estate. We do some other things to help investors in particular, with some business law, help them form, businesses that they need to be able to do certain things with their real estate if necessary. So we've got some business law components, but most of what I focus on is real estate.
Cool. So you are the person that's going to kind of understand the ins and outs of dealing with buyers and sellers. I like to always think, well, let me ask you, if the buyer and seller agrees, what is it that you can't really do?
Oh, I think almost everything can be accomplished provided there's agreement. In my mind, from my perspective as a real estate practitioner, as long as what they're agreeing on isn't illegal, let's go. I mean, that's my limit. Is if what they've agreed on is something the law doesn't allow, then that's where we have to stop. But just because you've got a standard offer to purchase in North Carolina doesn't mean the parties can't agree to do something other than that.
Man, is that me or you?
That's the thunder.
Good.
It left you and came to me.
we both have storms going on, y'all. So bear with us as this thing starts to get a little sticky. So today I was actually talking to Tiffany last week as I reached out to her. I have been reaching out to her for quite a while. Finally got her here.
We're blaming the new baby.
Yeah, new family, baby. I don't want to blow you up. New family, all that stuff. So thank you for your time. Due diligence. The first thing she was like, we need to talk about this due diligence thing. And I have no idea what it is. I
Mhm.
literally have never even heard of it. So round up, get your questions in today for Tiffany so she can answer all your legal stuff. She's not going to be doing, what do you call it? You're not giving them advice.
No legal advice. So basically,
Just
I
your
can tell you
disclaimer.
what I can tell you what this stuff means. I can tell you application of it, how it might play out, but I'm not going to tell you to do or not do any specific thing. That
Gotcha.
requires, an engagement with the firm. You got to be in North Carolina for me to give you legal advice on anything. But we can talk about what does this stuff mean? How might it affect the things that you do, or where might you see this pop up in your transactions? If your state doesn't have this, could you apply it somehow in a way to try to win a deal? I don't know. Maybe it'll work, maybe it won't. But if you never heard of it, then how can you ever try it?
You don't know what you don't know.
Mhm.
You don't know. So is this a new thing down there, or this has been around forever? And y'all got some crazy stuff going on down
We
there.
do have some crazy stuff. North Carolina's got some weird stuff in every area of the law. But due diligence is not new here. It hasn't been around forever, but the last decade or so, the due diligence fee it's just a staple in North Carolina real estate transactions. I don't know how many of your subscribers are on TikTok, but there's an investor on TikTok recently. He posted a call that he was having with a North Carolina real estate agent. He's trying to buy an investment property, and she's saying, "Hey, we will be expecting some due diligence money in that." And he's like, "Well, what's that? I've never heard of that." And the way he said it, I don't know, it kind of rubbed me the wrong way, because when he said, "I've never heard of that," what he was really saying is, "I've never heard of that, so it must not be real." And that's not the case. Just because you've never done it doesn't mean it's not real.
Not
I mean,
real.
it's like a lot of the stuff that you teach is your people have never done this. Your investors have never done it, but that doesn't mean that it's not real. If they would just do it, then they would start making some money investing in real estate. So I like to take the approach of, "Oh, I've never heard of that. Can you tell me more?"
That's exactly what I did. I'm like, tell me more. What is this? Let's do this.
Yeah, well, this guy didn't do that. He was pretty much like, "So, you're wanting a bribe, huh?" So that's not it. In North Carolina, the concept of the due diligence fee is intended to compensate the seller for their time off market.
Okay.
So basically, the buyer is paying some amount of money, it's negotiable, to have the right to check out the property. I know other states don't have this. And I know that if you're in a state that doesn't have it, you're like, "Well, I should just have the right to check out the property." I hear you. But in North Carolina, if you're buying property, this is the way that you're going to get the attention of a seller. If a seller's looking at a couple different offers and you've got somebody that's offering a due diligence fee and someone that's not, you should really consider that it might hurt your offer in North Carolina. And that fee is non-refundable. So the second you pay it, you don't get it back unless the seller breaches, but it does go towards your closing. So it's not as if it's additional on top of the purchase price. If you negotiate to pay $100,000 and you give out 1,000 due diligence, yeah, the 1,000's gone if you walk away, but you're only bringing 99 more to the table at closing. So it's just like an earnest money deposit in that way that it goes towards. It's just, is it refundable or not? So I think that's where people get hung up on, "Oh, it's non-refundable. It must be a bribe or a scam or, whatever." And it's totally just intended to make it worth the seller's time to not entertain anybody else as a buyer for the property. If you get a month of due diligence, then they want some money for that.
Being a real estate investor for forever, I feel like non-refundables are part of the business. Well, let me, I didn't put
They call it something else, like you could go to another state, or if you're doing commercial deals, they're just going to call it the initial deposit. Just because they don't call it a due diligence fee doesn't mean you might not be giving up some non-refundable money. So I think you make a good point there that the concept is out there other places. It's just the implementation here is what makes people a little like, I don't like y'all.
Yeah, I've never heard of it. I'm just trying to imagine, could you just go over what the purchase agreement would look like from, we got EMD, because even me, I'm like, shit, is it another line on the paper?
Yes, it is. It's exactly like that. So like our North Carolina standard offer to purchase has top line purchase price. And then Yeah, and you start deducting, whether that's your due diligence fee, earnest money deposit, assumption of any notes, and then you've got your bottom line. In North Carolina, it just says purchase price to be delivered in cash at closing. That just means whether you're getting a loan or not, that's just what you have to bring to the table. So when it says in cash at closing, doesn't mean dollar bills. It just means, that's what's left. So it just is another line item on your purchase agreement.
So we got 100,000 minus earnest money deposit. Let's say it's 500. All right. Then you got another line says not minus, but it's got a line for where you deduct due diligence fee on the paper. That's interesting.
Yeah. And the way we do it here is that the due diligence fee, you write 2 checks. If you've got an earnest money deposit and a due diligence check, you're writing the due diligence check to the seller. Seller takes it right then and there and deposits in their bank account because it's non-refundable. It's gone. And the earnest money goes to the escrow agent.
Well, here's the thing. All right, we're here. I'm here to push a little. I have given so much money. I can't even count how many earnest money checks I've given to sellers before starting out or whatever. They cash it, title's bad. Do you expect them to give the money back?
Well, the contract requires them to, whether they
but
do what they're supposed to do. That's the question is, are they going to do, if they have breached the contract, they can't deliver clear title at closing, then you'd be entitled to that money back. It's just a question of how do you get it? Do they give it willingly or do you get the court to give it? Our contract here says if you have to go after a party to recover something for breach, then you can get your damages, your attorney's fees. So if you're clearly right, then your attorney's fees are paid. So it lessens the risk a little bit.
Tiffany,
even if you're clearly right doesn't mean you're going to win.
I'm like, I have been clearly right so many times, and paid people. Yeah. But I'm like, why can both parties agree to put that in escrow too? I mean, I feel like I'm just so much safer.
Well, if you are a buyer, but it depends on the state of the market. It's just like any other deposit. Depending on the market you're in, your deposit might have to be really high or it can be really low. When the market is very buyer friendly, those due diligence fees are, pennies. It's just $100, whatever. But here is an example. I had an investor, and I might have told you about this last week. I had an investor last year when the market was kind of wild, was tired of losing out on property. So he put the entire purchase price up in due diligence money, non-refundable immediately. Like you're buying that house. So if he had decided to walk away, then the money is gone. Or, for example, if the title was not clear, then he's having to go to court to recover that money if the seller wouldn't give it back. But that's how powerful that a solid due diligence offer can be. We were seeing crazy offers, like routinely 100,000 plus due diligence fees. As an attorney counseling a buyer, I'm saying, don't do it. Don't do that. It's too high. That's usually what I'm telling them, because you're not getting it back. Attorneys like to see those non-refundable things low.
Yeah. I've done non-refundable. I mean, I've done the entire purchase price on an earnest money deposit too, but I'm like, shoot, I sleep at night because I know it's an escrow.
Yeah, it's an escrow. Yeah. And, as a buyer myself, I would much rather have my earnest money be, if I've got to put up a bigger deposit, I'd rather it be in the earnest money because I know if I cancel before due diligence is over or if there's some other issue, then the escrow agent's going to give it back.
Yeah. So how can the roundup, if you thank you for joining us. I'm here. If you're just joining us, we've been in 20 minutes already.
Time flies.
It's attorney Tiffany Webber. She's down in North Carolina. And if you want to reach out to her, if you have questions, if you want to hire her, possibly her information is in the video description. Thank goodness she's on social media. I don't know why attorneys, why don't y'all like to get on social media, man?
Attorneys, generally speaking, are afraid to try new things. I'll just keep it like that. Just leave it at that.
You could own the internet, yo. So anyway, I'll get your questions in very quickly on the chat if you got anything about this. Tiffany, what can be I want to talk about from the investor buyer. I'm always trying to get an edge when I make an offer. What would that look like if I want to say, hey, pick my offer.
Yeah. Well, usually it's making a meaningful due diligence in our state, making a meaningful due diligence deposit. So, like going back to this TikTok, the viral guy who's saying this is a scam, this is not real, I've never heard of this. He said, well, what if I say $25? Well, the agent is kind of responds of, I cannot tell you what to offer. I don't represent you, but I will tell you that that is not considered a meaningful offer here. I will present whatever you give me, but just kind of as a courtesy, you're probably not, like, I can't tell you what to do, but $25 ain't it. And so he's like, well, I don't want to give up. I don't want to give up any money. I don't want to just walk away from $25. And I think that was part of the issue, is that if you're closing, if you close, you're not walking away from it. It's just like the other deposit, but you do have the risk of, if you have to walk away, you lose it. I think it's interesting because in other states where you may not have something called a due diligence fee, you may be able to apply this concept as like one of your initial deposits of, all right, I'm going to give you earnest money of $1,000. Or I'll give you deposits of $1,000, but maybe I'll give you 100 of it non-refundable, and the other 900, however it makes sense, depending on the circumstances, on the property, whatever you've been able to. Risk tolerance. I believe everything is based on your risk tolerance. If you're willing to be a little more risky, you can do half and half or whatever. But I think that it could be applied in a competitive scenario to make you stand out a little bit.
I'm just thinking in general, if somebody's willing to walk away, I'm just like, as I get older, it's like money just has the value goes down. So many other things that are more important. Now, obviously, we all need it, but I'm like, man, I'm willing to give you $500 to say, look, I'm going to do what I say. When people see that, does it change maybe the mindset? This guy's willing to walk away from $500. I mean, to me, that's just people don't give away $1 now, as opposed to 500.
In my experience, yes, it does. And, sometimes I'll be doing closings. In North Carolina, we represent buyers, not sellers, unless we were engaged specifically by the seller. But the default is we represent the buyer. So if I'm in the room with the seller, I can facilitate them signing something and notarizing it, but I don't give them legal counsel or advice. But sometimes they just like to tell you stuff about the transaction. Like the client I had that put down $100,000, and the seller tells me as he's signing the deed, he's like, you know what? I can't believe they gave me $100,000 non-refundable. I was just looking for like 15. If they would have given me 15,000, but he said that's why I picked them. They're serious. I don't really have to worry about, okay, we're not going to go through 30, 45 days of closing and then walk away on day 44, because they're not walking away from $100,000. And again, I don't like when people put $100,000. You gotta be smart. But in that instance, he said that's why I picked them.
Well, at the end of the day, if you're going to buy the deal, it doesn't matter if it's 1,000 or 100. You're still going to buy the deal. You're going to buy. Real investors. I just feel like I'm not scared to put down this huge amount of money because I know I'm going to buy the property. It's irrelevant to me, really.
And after enough deals, the things that are deal breakers for you. And a lot of those things can be found in the public record before you ever go under contract. If there's something that cannot be fixed on the title, you can usually find that out before you go under contract. It's just a matter of, do you have the access or know what to look for? Or do you have an attorney that will do a title search for you before, like if it's a deal that you really want, but you think there's some issues lurking, before you make the offer, have somebody run a title search for you.
Yeah, that's
true. Then if you find something that's like, oh, that's a big problem that I don't know how to fix or they cannot fix, walk away. I mean, you don't have to make an offer.
Yeah, you don't have to make an offer. I have not yet ever had nobody put a gun to my head to say you are buying this or you're selling this. This doesn't happen, y'all. Andrew K had a question, Tiffany, about your example. I like at the beginning of it, could you just put a clause where the party that doesn't follow through will pay the other party's attorney fees if it goes to court?
Yes, you can. But usually the way it's drafted and the way you get the parties to agree to attorney's fees clauses is to say the prevailing party will pay the other parties.
Gotcha.
So rather than the party that doesn't follow through, because that party might actually win in court, whether you think they should or not. So usually those agreements do include, hey, if we got to go sue to enforce this agreement, then the prevailing party is going to get their attorney's fees. But that has to be agreed by the parties.
Before at the signing of the contract.
Mm-hmm. Yeah.
Yeah, you gotta do that. That's nasty. Sandrika said somebody was asking to put $20,000 down just to see the property. Do people want due diligence fees just to see the property too, Tiffany?
I don't see that very often, but nothing surprises me. So, typically we're not seeing those numbers go back and forth until after the property's been at least shown.
Wow.
There's no admission fee typically, but that doesn't mean it's not happening. I wouldn't be surprised by anything anymore.
Round up. If you're just joining us, I'm here with Tiffany Webber, real estate attorney in North Carolina. Her information is in the video description. And Alfonso wants to know, hey, Alfonso, how much do you charge to close on a contract, Tiffany?
Yeah, that depends on the type of property. So whether it's like a multifamily, single family residential, commercial, but North Carolina has some of the lowest closing fees of all the states. And because it's an attorney state, not a title company state. So you're not paying an attorney's fee on top of a title company's fee, like the attorney does pretty much everything. But I'd say most things are like $1,200 or less. I mean, it's like $700 to $1,200 range for closings, and that's usually inclusive of title work. So that's not in addition to title work.
Cool. Now I want to make sure that I don't put you on the spot.
That also depends on where you live too. So I should say that depends on, like I'm like north of Charlotte, North Carolina. So it's a little bit, Charlotte people charge a little bit more because
how far from Charlotte is that? An hour? 30 minutes?
30 minutes. Yeah.
Okay.
Just north, but those high rises are expensive in Charlotte. So that's why they got to charge more.
You're right. It is. Tiffany, for all the people out there that say, I can't find an attorney to do subject to, what makes you, a lot of attorneys won't even do this stuff, wholesaling, lease options, sub to. Why did you choose to say, you know what, I'm going to do this stuff?
Well, it depends on how it's executed. So to me, and this is kind of what I said at the beginning, is if the parties agree on something and it's not unlawful, then we can figure it out. I like to think that everything is figure outable. So provided what we're doing is not unlawful. And sometimes parties will come to me with something that they don't even know is unlawful. So I can say, hey, this, we can't do it this way, but what about if we try something else? So my default perspective is let's hear what you're trying to accomplish, and then let's accomplish it in the way that the law allows. So, we've got things that we got to work around with any of those types of deals, like lease with option. We feel pretty comfortable with those. There's special requirements that have to be met. Subject to is not the easiest thing for attorneys to close. And there's so many things that have to go right for you to have an attorney that can close it. And me included, I'm not accepting myself. So, if they say I can't find an attorney to close subject to, there have been times when I've had to say, I cannot be involved in this transaction if we do it the way that you say you have to do it. I got that license, and I know it might just be a piece of paper, but it was expensive to get, and it's going to help me make money a long time. So I want you to be able to buy your property, but I also want to be able to keep doing what I'm doing a long time too. So the reason why I think that I am pro creative financing is because I think there are ways to do it in every state within the bounds of the law.
Wow.
So,
that's so cool.
We just got to work. That's all.
I wish I had 25 cents for every time I hear my roundup homie say, Chris, I can't find nobody to close this deal for me. They can't find anybody.
I gotta be honest, that is a little tiny bit of a red flag. When somebody comes to me and they say, I've been to 3 attorneys and none of them will close it. And I'll say, who are the attorneys? And if they're people that I'm familiar with, and I know, the quality of their work and their integrity, and they've said no, that's kind of a red flag to me that maybe there is something going on that our state in particular won't allow us to work around.
Gotcha.
Like I said, North Carolina we're slow. We're behind the times. We haven't caught up with all of these ways to buy and sell property. So it is a bit of a red flag if somebody says, I already called, 1, 2, and 3, and they won't do it. Well, the answer is, let me investigate first. Maybe they didn't ask the relevant questions. Maybe they were in a rush and they didn't look for the details. Or maybe they just glossed over something big. But usually it's a sign that there may be something going on that the law in North Carolina specifically won't let us do.
Gotcha. Well, I'll leave you alone. I'm not going to dig too hard on this subject too, so I could go all day because we're talking about due diligence. Round up, get your questions in for Tiffany. We got a few more minutes. She's sacrificed her time, energy, and effort to come on here for us, and hopefully we'll get some stuff in the future.
Can I tell your people a bonus tip while we're on here?
Oh, yeah, go.
Outside of the due diligence, the marital interest thing I was telling you about.
Oh, yeah, that's right. Go ahead with that.
So I know that this is different. Oh, I want to know what this one is.
Go ahead. I don't want to distract you. I'll bring it up.
I love the questions. Okay. All right. So marital interest. This is a concept in North Carolina that's kind of based in, not to get too legalese, but it's a right that's based in your right to inherit from your spouse. So in North Carolina, just by virtue of being married to another person, if they acquire real estate, you get something called a marital interest in that real estate, unless you've got a prenup, a postnup, a free trader, separation agreement, something like that, where you are specifically waiving your interest in that property. So if you don't have that, then the default is, okay, my wife bought a piece of property and she bought it by herself. I didn't have anything to do with that. It was her money. Well, unless you've got one of those documents in place, actually, yeah, you got a marital interest. So when she goes to sell it, you've got to sign all the sale documents. You're a seller too. Yeah. And people will be, sellers from out of state. They'll come in, they'll buy property and they're like, wow, I wasn't even married when I bought that. And then I got married. What does my wife has to do with this? She doesn't have anything to do with this. I bought it before I ever even knew her name.
Oh, Lord.
Yep. In North Carolina, you have a marital interest is what it's called. So unless your spouse is willing to sign something to say, I don't want that marital interest, they got to sign all the sale documents. Yeah, people don't like that.
That's going to be tough. Yeah, babe, come sign us. It means you don't want nothing to do with this.
Yeah. Can you imagine having that conversation? Like, I don't want a prenup. I don't want a postnup or whatever, but I don't want you to have anything to do with this particular piece of property.
What you doing?
Not an easy conversation.
But I'm asking you, does the check come in both names too? Because I'm like, that the deed doesn't have anything to do with the HUD. They're two different things, or the CD or whatever. Well,
the proceeds can be made as directed by the seller.
Okay, so made as directed. But the seller's to both people now.
Not always. So it's not always something that we're required to cut the check to the spouses. Often, the spouses don't care. They're like, oh yeah, that makes sense. We're married now. Like if they've been in North Carolina for any amount of time, then they kind of get it. They know like, oh yeah, gotcha. Now we've got it. So just write the check to us, but not always. So, it'll be like, if I bought it before I met him, then, this goes into my special bank account just for me. And attorneys can accommodate that. Gotcha.
Andrew K, it feels like there should be a law on the books for a maximum amount of due diligence fees. I agree. Feels like a number. If a number is too high, people might get greedy and pull something shady. I guess they could.
Yeah, they could. I like that idea. I don't know if our legislature in North Carolina has contemplated something like that. It would be interesting for me to look after this to see, especially given the market the last couple of years, seeing those crazy high fees. My investor client who put up his entire purchase price in due diligence, that made my heart race. Because I was thinking about all the things that could go wrong. It went right in the end, but it had a lot of opportunities to go wrong. if there was a cap, then that would, have some protection for the buyer of you'll never walk away. Maybe it's not a dollar amount, maybe it's a percentage. You cannot
Yeah,
put more than a percentage of the purchase price up.
gotcha.
I don't know, but I like that idea.
It is a good idea. Maybe you could lobby that one day. Cash for the king. And what would you charge for $1 million property? You just simply wouldn't be able to charge enough. He said
That's
government
another
should stay
thought.
out of that.
North Carolina tends to take the approach of the parties can agree on what they want. It's up to them. What will the market bear?
Yeah.
And I think that's probably why there is no cap. It's what if the market will bear a buyer paying $100,000 due diligence that they'll never see again if they walk away, or if the seller disappears or whatever, then let the market do what the market's going to do.
Yeah, this could get real sticky. Round up, get your questions in here for Tiffany. We got a few more minutes. Can you, Tiffany, Michelle Bradley, can you close deals in Florida?
I wish I could. I'm licensed in North Carolina only, and I don't know if I'm up for taking another bar exam. Now I got that baby at home. It'd be hard to study, right? Maybe someday I'll change my mind. You know what, Michelle? If I ever get licensed in Florida, I'll tell you.
All right, that's cool. Andrew, about the Marital Interest tip you brought up. What if the property is deeded to a company entity that one owns? Does this apply only if the spouse puts it in their own name too? Good question.
Yeah,
That's
that's a
good
great
one
question.
right there. If I'm the owner, if I'm the man, I got it in my LLC. Go ahead.
Yeah, so it does not. It's not going to matter as far as like the sale. So if you own property in an LLC, your spouse may acquire some sort of interest in your
Mike?
LLC by virtue of your inheriting in your estate. But the property itself, if it's owned by the LLC, then the managers of the LLC or whoever the operating agreement says can sign is who's going to sign. So that would be a way to avoid that.
Oh boy, you teaching now, Tiffany. You're talking to my man out there with all the money. Use this stuff for good, y'all. Please.
Yeah.
Please use this stuff. Use this stuff for the forces of good and not the forces of evil. Okay, y'all?
Here's the forces of good. This is a way you can use this for good. Is let's say your spouse has a very demanding job and they travel all the time. You got a pilot or somebody that's all over the world all the time. They can't be there to sign the documents at the drop of a hat. So maybe as a convenience for the two of you, okay, you put the property in LLC, your trust, whatever, so that it's not going to require your spouse's signature every time. Or sometimes we see this with, especially like if it's a situation where spouse has a demanding job, but they've got marital interest in the property, they'll give limited power of attorney for the, your people that watch you, they know what that limited power of attorney is. It looks a lot like the one that you've got in your docs. It's specific to the property. It's for a limited time. You can sign for me. So that, that's ways to, if it's a matter of convenience, to not make your spouse have to drop what they're doing for every single closing, that would be a way that you could use that for good rather than for evil.
I'm telling you, man, this stuff, I tell people when you learn creative financing, in my opinion, you turn into a superhero. You could use those powers. I mean, who the hell can come in and do what we do? I mean, that's like 1% of the population knows how to do this stuff. And you can take advantage of mom and pa, screwing them over, can't get the deed back, all that, or you can have integrity and do it the right way. So, how much time we got, Tiff? It's 3:45.
I got a little bit more time.
Okay,
if
cool.
we got some questions, we can answer.
Yeah, I'm trying to put them in here. Oh man, somebody going on trust here. I love it. I love it. Tiff, first thing she hit me with, man, trust. Should drink it. That's why I put everything in trust. I'm not worried about a prenup because I own nothing. There you go. That's true. We'll get.
Do you have shirts with that on it? I need to look. I figured that's what own nothing and control everything.
I need to do that. Let me make a note of that. Own nothing, control everything.
Now, on the topic of trust, I already told Chris about this before we got started. If you're coming to buy property in North Carolina and you tell the attorney, I don't have my trust set up yet, but I need you to set up the land trust so I can buy the property. A North Carolina attorney is going to look at you and say, what? Do you have a conservation? In North Carolina, a land trust is a nonprofit entity that's set up to preserve land in the way that it is like current state. So like, you got wildlife or whatever, it would be like a conservation area, and you put that in a land trust. The attorney's going to figure out what you mean. They're going to ask you questions like, what are you trying to do here? You're buying a residential property, right? And they're going to say, oh, you need this other type of trust. You need a revocable trust, an irrevocable trust, or whatever. But if you say land trust, North Carolina attorneys might be like, huh? This is a house.
Well, anyway, all I'm saying is the concept can be done. I don't want people to think that, oh, you can't. It burns me up. You can't do that here. You can't do, I'm just saying that.
You can own property in the name of a trust in North Carolina. In fact, I tell people all the time that they'll say, I need a trust. And I say, okay, well, what do you own? What do you want to own? Because when it comes to, people wanting to avoid probate, they think that's a dirty word. Do not make me go through probate. Well, if your trust doesn't own what you own in our state, you're still going through probate. So you can set up your trust, but if it doesn't own your stuff, you still got to open your estate. You still got to go through probate. So if you've got a trust, it needs to own something.
That's nasty, right?
Yeah.
You imagine setting all that mess up and still having to go through just the fees would kill you.
I like to compare it to like a crock pot versus French cuisine. Like a will is your set it and forget it. Like, okay, I made it. I know who's getting my stuff, but then the trust is like your French cuisine. You got to go back and check on it. You can't just let it sit. You got to make sure that all the pieces you got to add stuff at the right time. You got to do all the steps, because if you don't ever transfer your house into the trust name, then you defeated the purpose of creating the trust.
Defeated the purpose. And I think a lot of guys like us, well, I'm thinking, speaking for me, you got stuff coming and going. You got things coming in here. You got stuff going out there. You got capital. I mean, it's always moving. Kian, thanks for joining us. Man, that's a pretty smile there. Jacqueline says, thank you for adding to her notes as a beginning investor learning. Good for you.
Nice.
Good for you. Andrew, yes, use it for the forces of good. Please. Mary. Oh, Tiffany. Oh, Mary. She's one of my masterminds. I have 3 rentals in an LLC, and I'm wondering if I should put them into a separate land trust, or in your case, revocable grantor. What would we call it in North Carolina? I don't know.
Revocable trust. Well, you could do irrevocable too, but
revocable trust.
Yeah, interesting.
If I do, can't my mortgage holders call the loan since it's now in the name of the trust?
I'm gonna have to speak generally, of course. I can't tell you what you should or should not do, but most deeds of trust in my state have what y'all talk about all the time, the due on sale clause or due on transfer clause.
Yep.
So a lender would have the ability to accelerate the note based on the transfer. Now, a lot of lenders that we work with in our state, you just call them up and say, hey, I set up this trust for estate planning purposes because it's the right thing to do for my family, and because my CPA or whoever, my attorney, my CPA, whatever, said this would be the right way to hold my property. What is your company's policy on approving that transfer? There's nothing that prevents you from talking to your lender to say, I am contemplating moving this property into my trust. I was advised by my people, my fiduciaries, the people that represent me, help me make decisions, that it would be smart for my trust to own the property. What will your company do about that? And they may simply say, nothing. Here's something in writing saying, we don't care, do it. And, I know that, Chris, you're going to say, I'm going to do it and we'll ask for forgiveness later. But we find that a lot of lenders have, their internal policies say, okay, for this purpose, when you're doing it to try to be smart about your money and not to avoid your obligation to us, then we maybe need you to sign something real quick to, say, okay, this is a new owner, or they have you execute a document that corrects the way the deed of trust reads. There's almost always a way to get it done. But if to answer the question, could the lender accelerate if you transfer? Well, if you don't have their permission to do that, yeah, of course they could. If that's what your deed of trust says, then yeah, they can do that.
Well, I haven't yet seen a deed of trust that does not say that they can accelerate the loan upon transfer of ownership.
I don't think I've ever seen one that doesn't say that either. Now, I'm curious in that question, what's the motivation for separate trusts?
She forgot she could reach out to the lender. Well, we put every house in a different trust. So
Okay.
once
I
again,
don't know that
everybody is
I've
different.
seen I don't know that I've seen your videos on that topic. I won't take your time on that. I'll go watch your videos to see what your reasoning is behind that. I'm just curious, why separate versus the
Yeah, let's do that. We'll go back and forth on another video because I mean you're the expert. I'm just a guy going by what my millionaire real estate
Well,
mentors have
I'm
told
not
me to
an
do.
expert on real estate investing. You are. I'm learning
Well,
stuff too.
we'll put it all together for round up homies then. Is that cool?
Cool.
Do land trusts or, well, in your case, revocable trusts expire after a certain amount of time, or do they exist in
Mhm.
perpetuity?
It depends on the drafting of the trust. So some trusts can roll into other trusts. Some trusts, once the grantor, the settler, or whatever you're called within that document passes away, then that trust terminates, and then separate trusts are created for the beneficiaries.
Good Lord.
This is a lawyer answer. I'm sorry. It depends. It
Wow,
depends
that's
on the
deep.
terms of the trust.
That's deep. Grantor and revocable trust. That's the same thing that I've used in other states with other clients with that. Not that I'm representing them. Mary, thanks for the answer. I forgot I can reach out to the lender and let them know what I'm doing. You can. You can do that. One trust fund property. All right, that's all we got. So due diligence. Final thoughts, Tiffany, to get you out of here on people. I'm gonna if there's a situation where I think that I can get ahead by giving somebody look, here's $500. Due diligence, you keep it. We look it over. I think somebody would be happy to get $500. You woke up, you got $500 that day.
Mhm. Yeah, just for the sake of saying, all right, I'll sell it to you, and if you back out, I get to keep this. The final thoughts on due diligence for me as a practitioner in North Carolina is that I know it's weird, but it's not a scam. It goes towards your purchase price. What
Let's stay there.
matters is,
Let's stay.
yeah,
Let's stay there. North
mhm,
Carolina, and then in general, yeah, because you
yeah,
have to do it. Like I mean, you.
yeah,
So
yeah,
let's do you, and then okay.
yeah. So in North Carolina, I think be smart based on the market, based on your risk tolerance. What amount of money are you willing to walk away from if you get into your diligence period and you find something that you can't tolerate?
What can
If
you
that's
walk
not
away
a lot
from?
of money, you need to make your due diligence fee low. If there is almost nothing that you feel like you can't fix, then you may be willing to put up more money. If you want the property that badly, you know that it's a winner, you got that gut feeling, then you may be willing to tolerate more non-refundable money.
Mhm.
In general, in other states where maybe this is not something that you do every day, or you call it something else, if your state law allows it, then it's certainly something that you could try to employ if you want to get an edge. I mean,
Yeah.
if it's allowed by law where you are, and you're willing to part with $100 or $200 to see if you can lock down the property over somebody else, that's a way to do it.
So we need to research it. So I can imagine it like not being legal. If I want to give you some money, why can't I
I
just give
can't
you some money?
either, but I think it's going to be more so, does it need to be drafted a certain way in the contract? Like North Carolina has
Right.
certain things that only attorneys can draft if you're not a party to the contract. So
I
like,
got you. I got you.
how do you have to word it so that it's correct? Who has to
Mhm.
write that?
Got it. Got it. This is a good one here. I'll let you go. What if the seller knows there's something wrong, Tiffany, Andrew, and they want that due diligence fee? That could be. I'm just like sellers. They get funky sometimes.
Sometimes they do. Well, in North Carolina, if they know there's something wrong that's a material fact, meaning it's going to be something that alters your decision, they are required to disclose that. If they don't, then there's a cause of action where you can recover your money. Now, just because there's a remedy that lets you get the money back doesn't make it any better.
Yeah,
It doesn't.
I got judgments up to yin yang on people that didn't pay rent to me. I mean, I didn't.
Mhm. And often I've seen that people that know how to work the system also become judgment proof. They know how to become judgment
Yeah, they
proof.
know how to do that stuff.
So there's a remedy in North Carolina for that, to answer the question, but I know that does not soften the blow if your seller runs off on you, because then you got to end up in court to go get the money back.
Gotcha. So be careful, y'all, how much money you're willing to walk away from. The older I get, I'm willing to walk away from so much capital because I know the opportunity is so huge. And I'm reading a book now where these dudes are putting up hundreds of thousands of dollars to hire lobbyists. They have to do campaigns to win votes for the city council and all this stuff. So many things that investors have to part with just to make deals work. All right. Now, I'm not saying that you guys are there right now, but just remember, sometimes you got to pay to play. All right. Round up homies. Tiffany Webber, a real estate attorney in North Carolina. Her information is in the video description below. Subscribe to the channel, y'all. Like the content. Tiff, good talking to you.
Good talking to you.
All right. We'll see you next week,
Bye.
guys. Peace.